Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good afternoon. That's kind of an abrupt stop to the intro. That was a little bit weird. Did it abruptly stop for you too? Well, good morning, good afternoon, good evening, whatever day it is. It is 1 o'clock in the afternoon. So it is afternoon, good evening, good afternoon. Today's Thursday, August 14th, 2025, and August is almost halfway over and it's been busy. It's been busier than it usually is this summer, it feels like, right? Crazy. The hearing on this case is at 2 o'clock, but I wanted to come on an hour early because we have papers. We have papers to look at. Remember the other day when we were just here on this case, these cases actually on Tuesday, Larry Tipton, who is the defense attorney for Brian Walshe, who was on camera the entire time, Brian Walshe, he said he made a motion to dismiss, and the judge said, well, I can't hear that today. So I want to go over the motion to dismiss with you because it's relevant to the federal materials and the Proctor communications that the Walshe defense is looking for. And, at what point is enough enough? Because you may recall that we watched a hearing with Judge Freniere, and we're going to look at a piece of that as well, all the way back in July, which seems like years ago. And Judge Freniere called out Laura McLaughlin as being the only person with the unique position of having been prosecuting the Karen Reed case and prosecuting the Brian Walshe case. And therefore, she has already reviewed all of the materials. And so she should know whether there's anything in those materials regarding Proctor's communications that could be exculpatory to Brian Walshe. She wasn't having any of it. But then when she came back the following week, she said, oh, guess what, everybody? I have the appearance of a conflict on this issue because the attorney that the Commonwealth has retained to represent them in the federal court with regard to Proctor's communications is a guy named Michael Sullivan, who happens to be, one of my mentors. So I can't hear this issue and this issue only. And so therefore, I'm going to send you over to Judge Krupp in Norfolk Superior, and he can handle it for all of the defendants. And there are 5 defendants who are affected with current pending cases by the federal order protecting Proctor's communications. First thing we can do is let's take a look at Boston 25 did a piece on this. They posted it on YouTube yesterday, but it'll give you a little bit of a review or a little summary. And it also has a little piece about the Karen civil case against Karen in civil court, and we went over those motion papers the other day. And so it's Ted Daniel, and let's listen to his summary of breaking news regarding this issue.
Breaking news in the civil lawsuit against Karen Reed. Court documents show Reed is filing a motion to dismiss several charges in connection to John O'Keefe's death. According to this filing, Reed's lawyers argue the plaintiffs, John's parents, brother, and niece, cannot prove they suffered negligent infliction or emotional distress, claiming they were not at the scene nor witnessed John's death. In response, the O'Keefes filed a memorandum in support of their claims, saying they have suffered and continue to suffer, alleging, quote, an unyielding barrage of harassment by Reed and her supporters. The next hearing in this matter is currently scheduled for September 22nd. Reed was acquitted in O'Keefe's death, but was ultimately convicted of drunk driving on the night of the incident. Also tonight, 5 defendants connected to murders in Norfolk County are still pushing to get former State Trooper Michael Proctor's text messages. Federal authorities downloaded Proctor's phone data during their investigation of the Karen Reed case. As investigative reporter Ted Daniel explains, this legal battle got heated in a Dedham courtroom.
The Norfolk DA's office has long had Michael Proctor's phone data from the Karen Reed case. The office is refusing to share or even review that data in other cases, citing a federal protective or secrecy order. Fired State Trooper Michael Proctor texted crude and biased.
There he is, sauntering into court with his attorney and his blue mirrored shades.
Things about Karen Reed. Now an army of lawyers want to see if Proctor said anything harmful about their clients. One of the defendants is Brian Walshe, who's accused of murdering and dismembering his wife Anna in Cohasset. Another is Myles King, who's charged with the 2021 murder in Milton. Norfolk's first assistant DA, Lisa Beatty, told Judge Peter Krupp the office won't touch the Proctor file until a federal judge signs off on it.
Your Honor, I believe reviewing the documents in this context would be a violation of a federal court.
That's a different question. The question is, does Rule 14 require you to review these documents?
I don't believe it does, Your Honor, in the current posture of this matter.
Attorney Rosemary Scapicchio represents Myles King and one other defendant seeking Proctor's phone data. She tells me it should have been turned over long ago.
A defendant's right to a fair trial, especially in a homicide case where you're looking to put him away for the rest of his life, trumps everything. And it should, you don't have to be told, Commonwealth, that you have an obligation under Rule 14 to investigate this case, to look at the evidence and to turn over anything that's exculpatory.
Scapicchio is also seeking Proctor's texts from his personal phone outside of what may be in the federal materials. Proctor's lawyer spoke to the judge. He said that Proctor got a new phone in February 2024, and that new phone...
Because of course he did. Because what happened in February 2024? That's when all of his text messages were released by the feds. And he got a new phone? Did he go to the same military base that Brian Higgins went to and crack a SIM card in half and put half in one dumpster, half in another? Or was he not allowed to go onto that military base because he's not a federal employee? Right after he was on the stand at the federal grand jury, thank you, Olivia, that's when he went and destroyed his phone. Do you see a pattern here? Anybody seeing the pattern here? Destruction of phones, failing to turn over evidence, Commonwealth attorneys playing dumb. There's 4,242 people here right now. I'm going to have to go look up that number in my angel number book. 42 is the number of the day. Anybody see a pattern here? And the thing about Rosemary Scapiccio's cases is that they happened before the murder of John O'Keefe. So she wants to go back at least a year prior to that because her client was arrested a year before. So she's entitled to additional information from his phones because if he showed bias in Karen Reed, is it possible, is it likely that he may have shown bias in cases that happened before the murder of John O'Keefe? Maybe.
Phone wouldn't have any relevant information. Reporting in depth.
Wait, what? Hold on. Oh, Proctor's lawyer. This is what Proctor's lawyer said. Daniel Moynihan, who's like a union guy, who's a union lawyer who represents a lot of cops trying to get their jobs back. He's also representing Proctor in front of the Post Commission to try and get reinstated.
To the judge, he said that Proctor got a new phone in February 2024, and that new phone wouldn't have any relevant information. Reporting in Dedham, I'm Ted Daniel for your local station, Boston 25 News.
I don't know. Somebody who knows this.
Breaking news in the
Talk to me like I'm 5. Just because he destroyed his phone in February of 2024, does that mean that his prior communications would not be available somewhere in a cloud forever? Wouldn't it be? Does it have anything to do with actually destroying the physical phone? Is there somebody out there who really knows the answer to that question that can really answer that for me? I'm not a techie. I don't know the answer. I don't pretend to be an expert in cellular forensics. But iMessages certainly are. Says Robin Hood. Depends on the carrier, somewhere in cyberspace. I mean, nothing's gone forever, right? Really? Is anything really gone forever? I don't know. Yeah, Olivia says, I'm just surprised that Proctor's attorney isn't from Marcy's old firm, Boyle Shaughnessy. Well, Larry Tipton, public defender Larry Tipton, I want to point out, he's not having any of it because we've seen a lot of Brian Walshe hearings lately, and he's really at the end of his ever-loving rope, Larry Tipton is. And we watched Larry Tipton try the case of Penny McGee in front of Judge Cannoni. It was a bench trial. And he's amazing. And he's a public defender. And listen, they're out there doing the Lord's work for very little money. In fact, many public defenders, I think they're all on strike in Massachusetts because they're only being paid something like, and they call them bar advocates, I think, in Massachusetts. Correct me if I'm wrong. But they're only making something like $65 an hour. They get paid by the state to do public defender work in addition to their private practices. And they're looking for a raise. Maybe if it's a murder case, they get, I don't know, $90 an hour, whatever it is, $65 an hour is not enough. It is like half of what all of the surrounding states are paying their public defenders. And they walked out. And so something like 100 defendants had to be released recently because of the speedy trial laws and because there was nobody to represent them. So Massachusetts, you need to get your act together because we are beginning, well, I have named it the state where your constitutional rights go to die. But don't you think that public defenders deserve to be paid at least as much as the attorneys who work for the Norfolk County DA's office? And I think the starting salary at Norfolk County DA's office is something like 90 grand a year. I don't know how anybody is affording to live in the surrounding Boston area on 90 grand a year, especially someone who comes out of law school with a ton of student debt. I mean, that's wild. I was just perusing Zillow the other day, and you can't even get a house in Canton for under $1 million. So I don't know what's going on, but I think you need to treat your public defenders with a little more respect. And, there's that, right? They're being paid by the state. So why shouldn't the state pay them? Thanks, Lady Di, as much as the county pays their attorneys? It's insane. And Adam Lally, I think the year Adam Lally tried the Karen Reed case, somebody can correct me if I'm wrong, because I know you guys have all the public records. His yearly salary, the year that he tried Karen Reed's first trial in 2024 was something like 140 grand a year. And he's been with that DA's office for 20 years. 20 years. And he's making less than a plumber. I mean, not for nothing, but it's an expensive place to live. So if I'm Adam Lally and I see that Hank Brennan is being hired to come in as a hired gun and being paid over $500,000 for a couple months worth work, trying the case for the second time, I'm pissed. All right. This is Brian Walsh's motion to dismiss or request for alternative relief. And this was filed August 12th, which was Tuesday. And that was the morning of the hearing that we covered on Tuesday. Defendant Brian Walshe moves to dismiss the indictments based on the violation of his rights to due process, a fair trial, and effective assistance of counsel resulting from the Commonwealth's Norfolk County DA's office failure to review federal documents pursuant to Rule 14 in its possession since February of 2024. But note 1. The Norfolk County DA's office notified relevant parties that it intends to file a motion to intervene in the federal district court on Tuesday, August 12th, 2025. The belated filing of its motion to intervene supports the defendant's motion to dismiss, given the likelihood that the federal authorities have now stated they will oppose any such motion. Counsel has not been provided any prior pleadings filed by the Norfolk DA's office in the federal court on this issue or a copy of the motion to intervene. Once again, they're hiding the ball, just like they always do. We've seen this film before, haven't we? Speaking of which, did anybody watch the Travis Kelce and Taylor Swift podcast last night? They broke YouTube. They had 1.3 million people in chat at one point. I was like, they didn't have any mods. It was just like a free-for-all. Could you imagine 1.3 million in chat mods? That's amazing. Back to the document. As grounds, therefore, the defendant, Brian Walshe, through counsel, states that 1, in these circumstances, Mr. Walshe has a state and federal constitutional right to have materials in the possession of the Norfolk County DA's office examined for information favorable to the defense as mandated by amended Massachusetts Rule 14 set forth below. 2, the DA's office has been in possession of the materials since February of 2024 and failed to address the destruction order effective July 18th of 2025 until approximately 48 hours before the destruction order was to be enforced. And then only when the defendant filed his motion for relief upon receiving notice of the impending destruction of documents. Footnote 2. The DA's office has represented that the destruction order was triggered as a result of 1, the end of the Karen Reed case, and 2, that where no appeal was filed, the documents were to be destroyed or returned to the federal prosecutors within 30 days of the end of the Reed case, which took it to July 18th because the acquittal was on June 18th. Three, the DA's office cannot insulate itself from its duty to conduct a constitutionally based search for Rule 14 information relevant to Mr. Walshe, where such evidence was produced in the context of an unrelated case where the documents are possessed by the DA's office. The DA's office, ADA Laura McLaughlin, has already conducted such a review in an unrelated case and informed counsel in that case that the federal documents may contain information favorable to the defense. I think I misspoke yesterday when I said that Laura McLaughlin had reviewed the documents and said there was something that was exculpatory to Brian Walshe. It's a different case. It's a different case. And I don't know if we know what case that is. Is it one of Scapicchio's cases? I don't know. Because we're covering so many cases that they're kind of conflating in my head right now. Manstat, if you know, you can let me know. And where ADA McLaughlin is assigned as a prosecutor in both the Reed case and this specific case. Failure to grant this motion or order in the failure to grant this motion or order the alternative relief will result in the violation of Mr. Walsh's rights to a fair trial, due process, to confront witnesses, to have effective assistance of counsel, and Rule 14, those rights guaranteed by the 5th, 6th, and 14th amendments to the federal Constitution, Article 12 of the Massachusetts Declaration of Rights, and Massachusetts Rule 14. Footnote 3. Counsel for Mr. Walshe have never been permitted to review the protective order at issue, has never been informed of what materials were produced by the federal prosecutors in February of 2024 to the Norfolk District Attorney's Office. Relevant background. Oh, the other case is Sandra Birchmore's? But that case is not being handled by the Norfolk DA's office, good citizen. That's being handled by the feds. And so I don't know. I don't know about that. Hang on one second. McLaughlin would have nothing to do with that federal case. But it's a good guess. On July 17th, 2025, the DA filed a notice, Commonwealth's notice regarding materials subject to federal court orders, stating in pertinent part that pursuant to an order of the U.S. District Court for the District of Massachusetts, Judge Casper, all confidential materials produced exclusively for the prosecution of Commonwealth v. Karen Reed will be destroyed or returned to the federal government on July 18th, 2025, in compliance with the federal court order. Pursuant to the federal court order, the confidential materials, including any electronic copies or work-related notes, are required to be destroyed, as the materials are the property of the U.S. Attorney's Office and FBI. Subsequent information provided establishes that the documents at issue were in possession of the DA, and the destruction order were in possession of And the destruction order were in possession of known to the DA since February of 2024 for over 1.5 years. There's a typo in there somewhere. It wasn't me. Upon the filing of the notice, the defendant immediately filed a motion seeking relief. See docket number 110, footnote 4, which says the issue was scheduled for a hearing July 18th, 2025, but that hearing never took place. Second hearing was held on July 24th, 2025, before the specially assigned Judge Freniere. That motion was never argued based on the DA's representations that it was unable to respond to the court's questions and defendant's arguments. On August 1st, 2025, a third hearing was held, but the court announced there was a conflict arising out of the court's relationship with the attorney retained by the Norfolk DA's office. As a result, this issue involving the defendant is to be heard by the court, Judge Krupp, by this court. On that same day, in a telephone conversation with prosecutors assigned to this case, it was reported that ADA Laura McLaughlin was assigned to both the Reed case and this specific case, had reviewed the materials at issue, and notwithstanding the present representations of the DA's office, had notified the parties in an unrelated case pending in Norfolk County that the documents may contain potentially exculpatory information relating to that case. Okay, so it's not Sandra Birchmore, because Sandra Birchmore's case is not pending in Norfolk County. It's a federal case, and the state has never brought charges because they quickly ruled out murder and they called it a suicide under the watchful eye of Lieutenant John Fanning, who happened to go to school with Matthew Farwell or something as such like that. They worked together. They were friends, colleagues, something like that. The review story was repeated that same day in this court by First Assistant Lisa Beatty. Footnote 5. In a subsequent telephone conversation, the First Assistant informed counsel that she was not entirely clear about what happened with regard to ADA McLaughlin's review of the documents for exculpatory information. The DA's office has failed to provide a copy of the February 2024 protective order to the defendant, any party or this court, that it claims it cannot be produced pursuant to the court order itself. Footnote 6, which says there are numerous protective orders that appear to amend or otherwise supplement the February 2024 order. One such order, dated December 2nd, 2024, was shown to defense counsel, but counsel was required to return it to the DA immediately following review in court. So they said, here you go. You can read it, but you have to give it back to us and you can't make a copy. This is something that hardly ever happens. Hardly ever happens. It's another situation that we're in that there's not a lot of precedent for this because this is so rare. So rare. But the DA is taking the position that, look, we're even in violation of the federal order to even give you a copy of the order or let you have a copy of the order. So we're not even going to give you, and we won't even give you a copy of the order or the motion that we filed in federal court because we think that would be a violation of the order too. And this whole thing is fakakta, and it's rarely happens, but all of a sudden the DA's office is worrying about ethics, which I find humorous because we've all been watching. Without seeing the terms of that federal protective order, I cannot even opine as to whether it would be a violation of the order to just show it to them. So I don't know. Could it be Aiden's case? It could be, because his case is pending in Norfolk County. And whatever they found in Karen Reed could correlate to Aiden's case. And it absolutely could be, because Aiden has said that there are some text messages from Proctor that they have possession of that are under a protective order that they cannot talk about, that are going to blow the doors off whatever Proctor said in the Karen Reed trial. For example, he said, I think it was with me yesterday or on his own show, that there's a group message, or it was in court. Bradel said it. There's a group message between Marcy, Proctor, Buchanan, and Tully about Aiden that says, Proctor says, why don't we just arrest him already? Why don't we just, that's exactly what it is. Ding, 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 ding. Well done. Well done, team. Well done. The DA has failed to provide a copy of the February order. Oh, no, wait, here we are. Since the above referenced notice was filed, numerous hearings have been held with no relief. On July 21, 2025, the federal court, Judge Casper, except for an extension of the destruction order for 30 days, presumably to August 18th, 2025. That deadline is fast approaching. It's not a complete sentence. Again, not me. And I love how Larry Tipton's documents look like they're typed on an old-fashioned typewriter. The DA requested a continuance of the hearing scheduled for July 25th, stating that it was expecting to meet with federal prosecutors that afternoon at 4 p.m. No additional information was provided. On Wednesday, August 6th, the defendant received a copy of a something dated August 5th, 2025, addressed to First Assistant Lisa Beatty. Oh, I guess she took Lynn Beland's position, because Lynn Beland was the first assistant before she quit and ran away, leaving skid marks. In summary here, the letter stated in relevant part that the federal prosecutors would not agree to or request an extension of the destruction date, warned the parties against filing a motion to intervene, and opined that access to the information must be requested pursuant to the 2E protocol. Well, we know how that goes, right? Even Hank Brennan said when he was arguing in open court about the 2E process, I've been there before. I've been trying to get, it's a long drawn out process that takes forever if you ever get anything. The federal prosecutors did not address in any substantive manner the defendant's state constitutional rights implicated by refusing to permit access to the documents. Footnote 7. The letter makes reference to the production to the DA of all of the Proctor communications previously produced. As of the filing of this motion, the defendant has not received from the Commonwealth a copy of what is specifically referenced in this letter. However, counsel acknowledges he has received Proctor communications in discovery. It is impossible to determine if the communications referenced have been previously provided. The cold, dark halls. That's it. That is it. Thank you. Detective McClurk. That's what Brennan said. The cold, dark halls of a federal 2E request. I've been in the cold, dark halls of a federal 2E request. Yep. That's right. Massad, I'm going to back you up on $65 an hour isn't much at all for an attorney who went to law school with many, many years experience, who's able to try murder cases. That is nothing. I live in New York, and don't even ask me how much it costs for a service call for the plumber to come here, or the guy to fix the air conditioning, or anybody to fix anything. It's like double that. So that is a joke. And I agree. I back you up on that 100%. Massachusetts Rule 14b2. The rules of criminal procedure and the rights implicated are at issue. On March 1, 2025, the amendments to Rule 14 became effective. In pertinent part, Rule 14b2 states that with regard to information favorable to the defense in subsection A, that the prosecutor shall disclose to the defense and permit the defense to discover, inspect, and copy all items and information favorable to the defense in the possession, custody, or control of the prosecutor, the prosecuting office, or any member of the prosecution team. Items and information subject to this section must be disclosed without regard to whether the prosecutor considers the items or information credible, reliable, or admissible, and without regard to whether any such information has been reduced to tangible form. This is a big change. This is a big change. And you know who was on the committee, the head of the committee to amend Rule 14, which is automatic discovery? The head of that committee was Judge Beverly Cannoni. And it took effect on March 1 of 2025. They went to amend it after Karen Reed's first trial. And I happen to think in large part due to what went on during Karen Reed's first trial. And now, instead of saying they have to turn over stuff that is exculpatory to the defendant, it only needs to be favorable to the defendant, which is a much lower bar. A much lower bar. The disclosure of any unwritten or intangible information shall be memorialized as soon as there is a reasonable opportunity, manner, and means to do so. In subsection B, the rule defines what constitutes items and information favorable to the defense are items or information that tend to, okay? It doesn't have to absolutely, anything that tends to, number one, cast doubt on an aspect of guilt as to an element of any count of a charged or lesser included offense. 2, cast doubt on the credibility or accuracy of any evidence, including identification or scientific evidence the prosecutor may introduce. 3, cast doubt on the credibility of the testimony of any witness the prosecutor may call. 4, cast doubt on the admissibility of any evidence or testimony the prosecutor may introduce. 5, support the suppression or exclusion of any evidence or testimony the prosecutor may introduce. 6, mitigate the charged offense or offenses or any lesser included offense or offenses, diminish the defendant's culpability or mitigate the sentence. 7, establish a defense theory or recognized affirmative defense or exemption to the charged offense or offenses. And you can see it is corroborate the defense version of the facts. It is far more broad than it was under the old Rule 14. It is clear that by disregarding the term exculpatory and detailing what is considered information favorable to the defense, the reach of the rule was broadened. The rule uses the phrase cast doubt on the credibility in describing such information as it pertains to any evidence, testimony, or admissibility of any evidence or testimony. The rule encompasses information that may help to establish a defense theory or corroborate the defense version of the facts. It is therefore clear that the government's Rule 14 obligation at issue to review information in the context of a specific case is far-reaching and requires careful and thorough review. To date, notwithstanding being in possession of the documents since February of 2024, no such Rule 14 review has occurred. Then they go on to talk about a case called Commonwealth v. Liebman, and they talk about the DA's failure to review the documents. And I'll scroll through this slowly. because I want to show you a piece of the hearing, and then this hearing is supposed to start at 2, but there's other cases on the calendar. So at least we got to get into the Zoom room and be ready. And so they talk about that case for a couple of pages. Much has been made of the supposed differences arising from possession of documents versus control of the documents. The DA's office continues to rest on this argument. It is important to note that amended Rule 14 repeatedly uses the phrase information favorable to the defense in the possession, custody, or control of the prosecutor. This argument continues to be made notwithstanding the DA's acknowledging that ADA McLaughlin did in fact review the materials and notified the parties in an unrelated case of the documents containing potentially exculpatory information. There was no such argument made in the Liebman case. The SJC was clear. Obtain the documents at issue in the or the case would be dismissed with prejudice. While the DA may quibble about an attempt to distinguish Liebman from the present case, any such argument must fail and is dubious at best given the underlying basis for this SJC's reasoning in the Liebman case. It was the defendant's right to, at a minimum, have the documents reviewed for potentially exculpatory evidence that controlled the outcome of the Liebman case. Alternative relief. In the alternative, the defendant requests at this juncture that this court order that, number one, the DA will be ordered to not destroy but maintain copies of the federal materials referenced in the notice before returning a separate copy of the federal materials at issue. 2, that the DA be ordered to conduct a review of the materials pursuant to Rule 14 and Brady. 3, that the DA be ordered to compile a list specifying what materials were in fact produced pursuant to the federal order. 4, that the DA be ordered to provide a copy of the protective order and any attachments or list of materials produced. 5, that the DA file a notice that a complete review pursuant to Rule 14 for exculpatory evidence has, in fact, been conducted with specifics as to who conducted and when the review was conducted. And 6, immediately produce any exculpatory evidence contained in the federal materials. XOXO. Please dismiss the case or give me some of the alternative relief that I asked for. Love, Larry Tipton. And here's the affidavit attached there too, with more facts, or most of the facts that we already heard about. Again, talking about Laura McLaughlin, her obligations and what she's already done because she did it in another case. Why can't she do it in Brian Walsh's case too? Let us go for a moment. Thank you, Floyd, for your very generous 50. Says, I've been watching these hearings with Aiden Carney, Myles King, et cetera, and it seems as though these are pretty serious issues. Do you feel the judges are responding appropriately? It seemed like the judge was rushing Bradel. Am I misinterpreting? Happens a lot. It happens a lot. But again, the judge has to try and be fair to both sides, right? So he's got to give everybody a chance. But at what point, and I'm with you on this, at what point, because we've been watching these cases so closely in this specific county, at what point does one judge say, listen, enough is enough? Enough is enough. They need to have some sort of ramifications for their continued behavior of failing to turn over discovery timely. The defendants have the right to a speedy trial. They've got constitutional rights. Civil cases take forever. And as a civil litigator, we're just used to that. But in criminal cases, defendants have rights that they're guaranteed under the Constitution. And you can't just trample all over their rights. You need to turn over discovery. You need to do it timely. Because these people are looking at life in prison, many of them. And it's no joke, but they treat it like it's a joke. And we saw the judge laughing yesterday. Was he laughing because he knows that the case against Aiden Carney is ridiculous? I don't know. A lot of people thought it was disrespectful that he was laughing. I took it as he knows this whole thing is ridiculous and he's just waiting to throw out the case, but I don't know. And so we've watched Judge Cannoni deny motion after motion for the defense. We watched it happen. And we watched Judge Freniere twist herself into a pretzel to deny the motion to suppress of Brian Walshe's searches of what was found on his phone, which I think was outside the scope of the consent. She twisted herself into a pretzel to allow it. And so, I mean, I think you have a great point, and I don't think you're misinterpreting it. And I think eventually they have to suffer some ramifications for their behavior, don't you? I think we all feel that way. Thank you for your 50. Olivia says the reason why these DAs keep doing this is because they know they can, because the judges apparently never hold them accountable. And that's what it feels like. And remember, in Massachusetts, these judges are appointed. They are not elected. And so some people think, listen, they owe people favors. I'm going to get in the Zoom room. The clerk was kind enough to tell me that there are cameras in the courtroom. She doesn't know if they're going to be broadcasting live. She also told me that there are other cases on for 2 o'clock, and so we may not be let in until that case starts, the case that we are here for, Walshe, etc. Hold on. Hi, Jojo. Thanks for your Tony says, I'm so pissed off that I want to go get a second degree in law and uproot everything to Norfolk County and become a judge just to get this circus moving. Well, it's never too late to dream a new dream, Jojo. If you want to go to law school, go. It's 3 years. It's 3 years. Thanks, Emman says, good morning to you. They should be able to get texts and emails from the cloud, but can't they get the info from the phone company? I don't know. I'm not a tech expert. That's what I'm asking. That's what I'm asking. No accountability in Norfolk County, people are saying. Let's go back to the Judge Freniere hearing and watch a little bit of that while we wait to get into the Zoom room. And this is when Judge Freniere called out Laura McLaughlin. And this was the hearing of July 24th. Many of you may have missed it. This is Judge Freniere.
I did on Friday. I understand from listening to the FTR. But regardless, it seems to me that we have a slightly different situation than maybe we have a different situation than what presents in some of those other cases. And here's how I think it might be different. Maybe I've got it wrong. But let me just start the discussion like this, in this way. It seems to me that A.D. McLaughlin.
I have this sped up a little bit, so just because it's like 20 minutes long, it's on 1.5, but I'll slow it down a little tiny bit.
It seems to me that A.D. McLaughlin is one of the signatories on the agreement as a result of being on the Reed case. And it seems to me that she is on this case, was in the grand jury throughout the 11 or 12 days of the grand jury. So she's intimately familiar with what happened in the grand jury. And otherwise is intimately familiar with what this case is about because she's still on this case. And being in that unique role as being A, someone who can look at the materials, and B, is assigned to this case, it would seem to me that she would know whether or not there were any materials that were required under Rule 14 and the case law.
Right. She should know. This judge isn't putting up with the games, but then she had to recuse herself because Michael Sullivan was hired by the Commonwealth and he was her mentor.
To be produced in this case. And that situation does not replicate itself in all of it. I don't know if it replicates itself in any of the other cases that people were involved with Judge Krupp last week. I don't care about those cases. I just care about your case, this case. So it would seem to me that with that pause, I understand that Judge Casper has put a 30-day pause on everything for people to assess the situation. And it seems to me that what needs to happen is that A.D. McLaughlin, who has access to that information, needs to determine as an initial matter whether there is anything in those materials that would be required to be produced under Rule 14. And if there are, we'll deal with that. And if there aren't, then the Commonwealth needs to aver by think of it a bunch of different ways, affidavit or otherwise, that there aren't any. Now, the backdrop to this is, as we know, and I'm not going to get the exact language correct, but when we asked for a TUI request earlier in this case, we got a, we're not giving it to you, but by the way, there's nothing there. That's my paraphrase of it. But that doesn't relieve the Commonwealth of its obligation. So that's how I frame the issue in my mind right now for this case. And I guess it's the defendant's motion that brought us here and alerted me to the issue. I mean, the Commonwealth gave me an email before that, but Attorney Tipton, what do you think about that first shot? Attorney Porges.
So I had a brief discussion with the Commonwealth this morning, and my understanding is that they're filing a request to impound the protective order in which they would show it to the court, show it to us.
They did.
Okay.
Did you get that before the hearing?
We did. So we have the protective order. So our main concern this morning was asking the court to order the Commonwealth to review the material for any exculpatory material or issues. If the court's inclined to do that, then I don't need to be heard further. I would just highlight that a case came down just yesterday that is decidedly on point with this issue. You're smiling because you know you're smiling because you
I think I know.
Okay. It's Commonwealth versus Okarian, and I would refer everyone to the section that discusses possession, custody, and control. Furthermore, the new revised rules under the Mass Rules of Criminal Procedure do a very good job of clearly explaining and expanding what exculpatory means. And in this situation, they are arguably in the possession of federal grand jury material that was investigating not only Trooper Proctor, but possibly the integrity of a murder investigation done by this very county, by these very officers. And so I just want to be clear that if the court is going to order it and the government is going to accept the order, that we want to make sure everyone has the same understanding of what exculpatory is. So otherwise, I have nothing further unless the court has any questions.
This attorney's name is Kelly Porges, and she is working with Larry Tipton, their co-counsel.
No, although, let me see if I can get to that paper. So I like to take things very logical person, I like to think anyway. So I like to take things step by step. So we'll just go in that manner and we'll cross each bridge when we need to.
Okay.
But I know two particular parts of the order that got my attention.
But when you say order, do you mean the protective order or do you mean the motion that Mr. Tipton filed?
The protective order. And one is paragraph 14, which may bring you somewhere else. And I'm doing this I'm putting the high beams on for your future, should we need to.
I love that. I'm putting
Paragraph 14.
I think that's a bridge
I'm putting the high beams on for your future. I'm going to start using that. I'm putting the high beams on. Pay attention.
have to cross.
Yes, and
At one point.
yes. And the other paragraph that stood out to me as having relevance to this issue is the opening sentence or all of paragraph 11 with regard to the issue of possession, custody, and control.
The first sentence of paragraph 11?
I think it might be one, yeah, yes.
So
But we don't have to,
I don't think.
I'm just alerting you to those two paragraphs because there are two things that caught my attention as we move forward on this issue, but let me hear from the Commonwealth first with regard to
Okay.
what, and then I'll go back to the defense. Thank you, Attorney Burgess.
Thank you, Your Honor. So it's kind of a unique posture because my co-counsels are not party to viewing the protective order at this juncture. So First Assistant Lisa Beatty has been in contact with the Special Assistant.
What does
Attorney General.
supervisor mean?
That would have
Laura McLaughlin speaks. Somebody said I've never heard her speak. We heard her speak like maybe once pre-trial, Karen Reed, pre the first trial, when she said that she had been through all the federal documents and none of them were exculpatory. So we already know that she lies. Take it back a second. If you're just tuning in, this is the hearing from July 24th.
First Assistant Lisa Beatty has been in contact with the Special Assistant.
What does
Attorney General.
supervisor mean?
That would have been the chief of the appellate unit at that time who signed the protective order in 2024. So at
But it says, is that right?
that was the way.
Hold
they
on a
were-
second. I just want to go back and see what the,
Could somebody get her a steamer?
so I refer you to 6B.
From-
What is that?
I don't know. Maybe wear blazers that don't wrinkle so much because all we ever get to see is her wrinkly back. And my OCD, it makes me crazy. There are fabrics that will not wrinkle And maybe that would be a better choice. I'm just saying.
When that was drafted, it was relative to supervisors assigned as part of the Karen Reed prosecution.
Right,
So at that time, it was the first assistant, Lynn Beeland.
but it wasn't just appellate supervisors. It says
Correct.
10
Correct.
supervisors of counsel of record. So anybody that was counsel of record supervisor.
Correct.
Could be multiple levels. I don't really know. I haven't studied your corporate structure.
Correct, but as I can say today, well, defense counsel has the opportunity to review the protective order. My co-counsels have not had that opportunity. So Lisa Beatty is in contact with the Special Assistant Attorney General, who has an update. She's on Zoom. If your honor would like to hear from her, where the office is working with the U.S. Attorney's Office about any future amendments to this protective order or any additional clarification that the office is seeking about any potential further disclosure. So if you would like to hear from her, she is on Zoom and could fill the court in on recent updates that occurred this morning.
Yes, please.
She's like, please, please, can I stop talking? Talk to someone else. You are not late, Daniel. You're not late. We're catching up. We read a motion that may be heard today, and we're catching up. It's going to start at 2. We're waiting in the Zoom room. This is from July 24th. This is when Judge Freniere called out Laura McLaughlin as being the one who has access to the documents and should have already reviewed them.
Welcome, ADAB. I can't hear you. Hold on. Can we try that again?
Can you hear me now?
Yes, I can. Thank you. I can't see you anymore, but I can hear you.
Can you hear me now, Your Honor?
Yes, and I can see you.
Okay, great. Thank you. Your Honor, I'm in the process of drafting my notice for Judge Krupp, which is due in 18 minutes. And I got a call from our counsel informing us that at this time we will be able to view the protective order. I know that not all assistant DAs in the office have been able, and I have not been able to view the protective order until I just learned this information. So I can't speak to what's in the order. So that will be able to be changed if there are ADAs who have matters that are in the posture that we are providing discovery and need to address these issues. ADAs will be able to look at the order. In addition, defense counsel, after the state court and defense counsel have signed a protective order, defense counsel will be able to have a copy of the July 21st order as well as the December 2nd protective order. Those are sort of my updates as I'm receiving them now. And then the U.S. Attorney's Office has acknowledged that we need additional accommodations or modifications. I don't know the exact words that they would use, but we have additional requests in order to be able to move forward with cases in a productive manner. And they understand that we're going to continue to engage in dialogue with them and possibly the federal court about how to manage these situations.
All right. Thank you for the update.
Now, just add, the case that came down yesterday is distinguishable because in that matter, the SJC said that the DA's office did not have those materials, that federal materials, perhaps a protective order, remain in the custody of the federal government. That case is distinguishable because a Worcester police officer participated in the interview and had personal knowledge that he could have discussed or disclosed to the ADA, that the ADA did not pursue that information that would have been held by a Worcester police officer. It is distinguishable that pursuant to this order, that materials do remain in the care, custody, and control of the federal government, and the DA's office is just prohibited from any further disclosures.
So what of my suggestion with regard to your role?
That is a role I understand. That is a role I can represent to the court in a different matter. Upon my review of the materials, I saw a statement that was very late exculpatory in a different case. I spoke to the U.S. Attorney's Office about that matter and had to advise defense counsel and trial prosecutor in the office that they needed to seek a two-week request.
Trial prosecutor.
That directly, the U.S. Attorney's Office did not.
Trial prosecutor. She didn't say my fellow DA. So it was definitely Aiden's case, in my opinion, because they had to hire outside the office for Aiden, just like they did for Karen Reed's second trial.
Produce that outside the protective order. Defense counsel and the Commonwealth had to seek that information. I provided date stamps, numbers to counsel, and they had to go to the U.S. Attorney's Office.
But I'm suggesting that in this case, you do that first step.
And that, I would say, has been done, and it's sort of in a similar posture where we represented to counsel that you need to file a two-week request. Counsel filed a two-week request. The Commonwealth filed its own two-week request. the U.S. Attorney's Office denied that.
But the difference is, in the other case, you identified a document that you believed. What I'm asking the Commonwealth to do, and I'm asking you to do it now in light of the new rule of discovery, not the ones that may have applied when you did it the last time,
Yes,
is
Your
to
Honor.
review those materials and identify whether we even have something to worry about.
And the understanding would be trying to, without knowing the defense theory of the case and seeking the broadest, what is most
That's
favorable to
always
the defendant.
that's always your problem. I don't mean you. It's always the prosecution. That's, I mean, they make that argument, I don't know, a couple times a week before me when I'm sitting in a criminal session. They can't possibly do as good of a job as me. And yet you have to. That's what the rules require.
And I understand my obligations as a prosecutor to do that. It just becomes a difficult conundrum where if there was a matter, I cannot disclose it to defense.
A difficult conundrum. It's a conundrum. So many words that we've invented during the course of our time in Norfolk County.
Counsel, I cannot disclose it to the court.
I
due to the
understand that.
response of the order.
I understand that, but why is it not, I don't want to say it's easy for a solution. It puts a huge burden on you. I don't know how much materials there are in there. But why isn't it the first step that we should be taking here is we have somebody assigned to this case that has access to those materials by virtue of the fact that you were assigned to the Reed case. And you acknowledge of this case by virtue of your affiliation with the case and your prior stuff that I said. Why isn't the easy first step for everybody other than you in the courtroom who has to do the man hours, for you to make that analysis and at an initial matter say there is or is not something in the materials that we need to disclose?
Right.
And I can represent to the court that the materials that were produced are related to the investigation of the death of John O'Keefe and not any materials related to the investigation of the death of Anna Walsh.
All right. Well, I appreciate that. That's well short of what I'm asking you to do, which is to avert to me, probably by affidavit, that there is or there is not information in. I understand their focus was on that. That doesn't mean that something doesn't make its way in to that file and those records. And I want some assurance that somebody has laid eyes on those documents and recognizing that it might be unlikely that there's anything to do with this defendant in those records. Close that door.
And to do so, Your Honor, I believe we would have to seek guidance from the U.S. Attorney's Office to make sure it's not outside the confines of the protective order.
Outside the
Because way
confines.
protective order says
Well, the
If
order
somebody
allows you
is
to
against
review
it.
it, right? The order allows you to review those materials.
for use in the state court action against Karen Reed.
So have you sought guidance from the court with regard to for review in connection with any other cases?
I believe that is what ABAPB has represented with, where the Commonwealth can't represent itself in federal court, a assistant attorney general has been appointed, and I believe there's ongoing discussions.
All right. Headed to another meeting on this probably next week because I don't want.
And then sadly, what happened next week was that she had to recuse herself because of the appearance of conflict, because the Commonwealth had hired an attorney by the name of Michael Sullivan, who was a former mentor of Judge Freniere. And here we sit in the waiting room of courtroom 25, waiting for today's hearing to start. Anyone who is actually on the Zoom yourself, if you are on the Zoom for the court, please mute your mic, because if you don't mute your mic and I'm talking in your computer, they think it's me. It's happened multiple times. Mike P. from the 413, thanks for your 5. Could the other case be Turk? Reddington did attempt to get some Proctor stuff when the case was still with Canoni, but per her record, she denied it. I think it was Aiden's case. That's what I think. But he was involved in the Turk case as well. And so I'm not quite sure. Thank you, Mike. Julie says, can Krupp call the feds in and ask why they won't allow the release? If I were the victim's family, I would be wanting answers. Yeah. Somebody suggested to Krupp the other day, Judge, is there any reason why you just can't call Judge Casper's clerk and find out what's going on? And if there's an order and if they're going to issue an order and because what they're saying is that the U.S. Attorney's Office is saying, if you intervene, we're going to object and we're not going to help you. Like, don't do it. But somebody did ask Krupp to pick up the phone and call the clerk, and he didn't really answer, kind of. Right? Michelle says, you could reach out to Michael Easter to interview. That's a great idea. I don't know how to reach him. When I have time, maybe I'll be able to do that. That'd be great. I would love to hear a lot of the things that he has to say, but just so busy covering other stuff that it's hard for me to watch, because I know he's been interviewed a couple of times on other channels, and it's hard for me to, I don't even really know what he said because I have not even had a chance to watch, but I'm sure he's very, very interesting. And considering that he was going to be one of the experts in the Karen retrial, number 2, but he was not allowed to testify. I really want to know what he has to say because it must have been really, really, really damaging to the prosecution or the Commonwealth in the Karen Reed trial, number 2. And that's the whole reason why he wasn't allowed to testify, in my opinion. I disagreed with that decision wholeheartedly. Mary Louise, thanks for tuning in from Sweden. Says good evenings from Stockholm to you. Beautiful. After today is celebrating my birthday, I end by following your coverage. Oh, happy birthday. Everybody's happy birthday to Mary Louise. Thank you so very much. You made mistakes in your email. We impound vehicles. We seal documents here in Texas. I'm late. This judge needs a cough drop or pickle juice. You're not late because that was the hearing from July 24th. So we're still waiting. We're still waiting. We're waiting for the hearing to start. It's supposed to start at 2. It is 2:01 right now. Thank you for your super chat. And another one says, Melanie, I will volunteer to steam it for Laura McLaughlin. Only caveat is she has to keep it on. Thank you very much. Detective Snarkasm, the upside in the Turtle Boys delay is each time more corruption is uncovered and more lawyers file Rule 14 motions. So the DA's office hole keeps getting deeper. Yeah. But it's, when you're a defendant and you're paying for every appearance and you're paying for every hour that your lawyer works, it's very frustrating when things don't seem to be happening and time seems to be wasted in court. And then you're paying for an entire day of your attorney's time and nothing happens. It's incredibly frustrating. And it's the defendant that has to bear the burden of that financial cost. And that's terrible. The only roll she knows is a Tootsie Roll. Thank you. Thank you. You made mistakes in your email for another super chat. Josh says, I don't find it coincidental that the Commonwealth hired an attorney that caused the judge to recuse. Yeah, we talked about that the day it happened. I thought the same thing. I'm like, oh, do you think they hired Sullivan on purpose, knowing that Freniere would have to recuse? I don't know. Floyd says, was McLaughlin sanctioned for misrepresenting that there was no exculpatory evidence against Karen Reed? No, she wasn't. She sure wasn't. And a lot of people think she's a lot more involved in some of these shenanigans than has been proven yet. And so that remains to be seen. But is she like the person behind the curtain? I don't know. Thank you, Floyd, for your 10. PJ Wolf became a member. Welcome. Love my flip-flops. Gifted 5 memberships. Thank you very much. It's very kind and generous of you. And good afternoon, Cherie. Good afternoon. Thanks for being with me for a whole entire year. That's awesome. And so we wait. Mel says it's very fishy that the judge recused herself. Makes one wonder if there was another under-the-counter push because she was actually applying the law as it should, and the Commonwealth are at risk. Well, she did not allow, and I thought they had very good grounds to have the suppression motion granted for the Google searches because, in my opinion, it was outside the scope of the consent agreement that they had to search his devices. However, she twisted herself into a pretzel in a very long decision to not allow those Google searches to be suppressed. So I don't know. Sometimes I like her. Sometimes I don't. I vacillate. Laura says, that's why Lally let Brennan step in it with the holes in the back of John O'Keefe's hoodie. I would have done the same thing. Another Melanie says, it's always the quiet ones you need to watch. Robin says, Alan Jackson doesn't seem to like her, meaning McLaughlin, and I take that as a good sign for all of us to follow suit. The Krupp shun runs deep. If anybody finds out that one of the networks is broadcasting this hearing on YouTube with better camera angles, let me know. Because we're still sitting to be let into the room, as is Young Jerks. So we're in good company as we sit in the waiting room. Will anything happen today? Probably not. Bettero is on vacation. That I know. And I think I heard that he got kicked out of the Zoom room yesterday during Aiden's hearing. He got kicked out of the Zoom room. We were in there the whole time. I think they're just going to kick the can down the road more. Something's got to happen with these Proctor communications. And in my opinion, there's a big reason. There's a big reason why Laura McLaughlin does not want to turn them over. She's already looked at them. She knows what's in there. Why is she being so difficult about it? Is she really concerned about her ethical obligations? Because the judge is just saying to her, just review them. You've already reviewed them. And as an attorney in the county, you know what other cases are pending with Proctor as the lead investigator. There's 5 of them still remaining. Turk was the 6th. You know which ones they are. And you know when you're reviewing those messages and going through those materials, it'll trigger you. Oh, yeah, that's related to Brian Walshe. That's related to another case. Come on. Let's not play dumb. MS808 says, I agree about Doolin. It's just at the same time, he's so easygoing, but it's almost too easygoing, kind of like rushed and laughed a lot. I don't know. It's people's time and money. Ha ha, ha ha. That was wild. That was wild what happened yesterday. All the things that we found out about Aiden Carney being in possession of Jennifer McCabe's text messages from January 29th, 2022 to February 2nd, 2022 between Jennifer McCabe and Allie McCabe. What do you think those text messages say? Oh, that's so funny. I have Young Jerks up because so I can see if he gets in, and we're both in the same courtroom and somebody's over there trashing me in his chat. That's hilarious. Hey, mini bike madman. I've begun to believe that the most vile people on the planet Earth are actually on Twitter. Those are the most vile people on Earth. Lady Laura says, I think they're going to send them to jail. You mean the McCabes and the Alberts? What do you think are in those text messages between Jennifer McCabe and Allie McCabe? And what other text messages did he say that he had? Jennifer McCabe and Yuri Buchanan, maybe? Yeah, Olivia, you're not vile. Scamaginnis says, I'm betting that Judge Doolin went home and voted in Ratchet Madness. Did Cosgrove win that round? Because that is one thing that Cosgrove did yesterday was gave Judge Doolin a copy of the Ratchet Madness as part of his reasoning for why Aiden Carney should not be released any of the information, because he'll just go on his YouTube presentations and make fun of them. And so there's that. No, I'm not streaming Mike's channel at all. I'm streaming my own channel. I'm just watching his chat on my phone. So that is not true. I'm not streaming his channel. I'm streaming my own channel. That's what it was. Thank you, Lindsay. Not that Lindsay. He had text between Jen and Kaylee. That's what it was. The niece. Can you imagine if those texts say something like, Kaylee is John O'Keefe's niece. Kaylee is a plaintiff in the wrongful death action against Karen Reed. She's got a claim for intentional infliction of emotional distress. She is claiming that Karen Reed, because she had to borrow Kaylee's phone to get Jen McCabe on the phone, because Karen didn't have Jen McCabe's information on her phone or contact info. Kaylee's claim is that because Karen allegedly said on the phone to Jen McCabe, maybe he was hit by a plow. Did I hit him? I think he hit him, that she suffered emotional distress. And so she also testified that way at the trial, right? Both of Karen's trials. And so was she being coached to say that? Remember what you heard. I don't know. But I'm waiting. Wouldn't that be interesting? Wouldn't that be interesting? A lot of people have had their reservations about Allie McCabe picking up Colin Albert at 34 Fairview. And the whole story about the dog that she found earlier in the day and then brought it to the Canton PD. That whole story was told out of nowhere for no real purpose that I can see. Remember that from trial number 1? Allie McCabe's testimony about the dog that she found. So bizarre. Angela says, oh, Jen and Kaylee. I wonder what those say. Jen is setting up and working her story to get Kaylee on board. I think it's very sad. I do. Me too. CPU Mod 1 says, I still find it very sad that Kaylee didn't get to go to the high school of her choice. Remember, John and his friend were out celebrating that their daughters both got into the very prestigious parochial school, Bishop Thean, I think. And then she wound up not going there and going to Canton High School. The recommendation and suggestion of Jennifer McCabe. Carrie thinks the dog story was just in case someone witnessed her with a dog in the car that night. Poe Hunter said Allie's 360 didn't match her story. Oh yeah, and remember when she was confronted about that on the stand? That was crazy. I don't know why they're not starting the Zoom for us. It's 2:12. Jojo said, in a wild opinion, people in power shouldn't be comfortable. Why not take a chapter from GRRM's GOT Game of Thrones? Just saying. Thanks, Jojo, for the 10. Yeah, I still want to see the timeline that they made too. Right. She rage nets. Even more bizarre is if there was a dog, Canton PD gives out names and addresses with no regard for privacy. Well, that was the other weird thing too. Didn't she say that she got the dog and she brought the dog to the PD, and then while she was there, somebody called in and said it was their dog, and she brought the dog to the person's house? Olivia, what do you think? She wants to know, what do I think the odds are that the intentional infliction of emotional distress claims get thrown out? I have to read the case law. Oh, here we go. Everyone turn off your Zoom. Rarely are cases thrown out before discovery. And so for that purpose only, oh no, wait a second. Oh, the host has joined. Okay. The chances are slim, but if the case law is very strong against it, it may happen, but I think the chances are pretty slim. Although I've said that those emotional distress claims, I think, are tenuous at best, but it may be a better time to make that motion, and they can make it again, would be after discovery. Oh, look at this. The dog story is surprisingly legit, says Olivia. I vetted it and found the original dog owner and report. Wow, it's legit. All right. If Olivia researched it, then I'm going to say that it's accurate. That's surprising. Olivia, I don't know that I even knew that you ever researched that, and that's awesome. All right, the host has started the meeting, so we are just waiting for the meeting to start. Hi, PJ. This has been around for quite a while. Thank you. Thanks, Karen, for becoming a member. And Emlyn, thank you so much for your super sticker. You made mistakes in your email, says Cupcakes. A bit of humor to help out. Tomorrow at 8:04, I will go back to being 56. I go backwards now. That's awesome. That's awesome. Thank you for another super chat. Melissa Garcia says there was no dog DNA, but sure, Jen, we can test it. Kate says, I find it extremely interesting that Canton PD is 1 mile away from Allie's house. I have questions about her Life 360 data. Brendan says, what do you think the odds are that the real person involved in John O'Keefe's crime gets prosecuted? I think the public is not going to quit. I think the public is not going to quit until somebody's arrested. So I don't know. I think the odds are pretty good. All right, they didn't turn the camera on yet, but we're here. What do you guys think? I mean, it's 1 of 10 people, right? John O'Keefe was not hit by a car. Something else happened to him. And why did none of those people who were inside the house ever think that anything else could have happened to him? Like a car could have driven, someone else's car could have driven by and hit him and killed him. They pointed the finger immediately. Karen Reed, why? Explain that to me. Right? KBD, there's no statute of limitations on murder. All it will take is a new DA. I don't think Michael Marcy is going to be reelected, do you? He's up in 2026. And, you know, they can keep these cases open. Kindergarten Cop is so on it. Microdot says if they'll point to Higgins, yes. None your business. One of my favorite usernames. Don't underestimate the power of the dark side. Microdots is here. Microdots is always here. People are happy about it. Jackie says, I really hope he gets justice, but in that town, there is zero hope. I don't know. I kind of think, I think the public's not going to let it go. There's a trial going on right now that had been a cold case. I can't think of it right now, but, and I think they're still in jury selection, but it's something like 20 years after the fact. The husband was arrested. I don't want to misspeak, but I think Court TV is covering it. Yeah, Kim says I don't think the family would protect microdots. Microdots. I don't think the family would protect Higgins that much. Sunny Moon, did we ever find out what happened after the feed cut when it was King's turn the other day? No, it was just put over until today. That's all I know that happened. Because we watched a news piece at the very beginning that covered that day of court and they didn't say anything either. No, everybody smash the like button while we're thinking of it. Helps the algorithm. Thanks, Julie, for gifting a membership. You're sweet. You made mistakes in your email, says those rubber bands they call workout bands are not for my age. I promise. Now, after using those bands, I know what slapping the taste out of my mouth feels like. I ate a jalapeno. No taste. I don't know. Do you have a latex allergy? Because some of those are made of latex and I don't know. Thank you for your 10. Sunny Moon, did we ever find out what happened after? Nope. We just covered that. Not unless anybody else heard anything. All I heard of was that they were told to come back today with the rest of the parties. Aaron says, sorry if this is a bad question, but at some point, wouldn't you think the Massachusetts Attorney General would step in and do something about this DA's office? mean, there could be an ongoing investigation that we don't know about. Could be wiretapping, all kinds of things going on. I happen to think that they are keeping a close eye on this. But that's just my opinion. Thanks, Aaron. KF did go to the private school for 1 year. My kids went. She did? She went to Bishop Fan for a year? Hold on. I didn't know that. Thanks, MG. Tracy says, does Karen Reed trial, 2 trials mean built-in reasonable doubt? For what, sweetie? With regard to what? Reasonable doubt does not come into play with regard to her civil case, if that's what I mean, the wrongful death case, the car accident case. It's a totally different lawsuit. It's a totally different standard of proof. It's a preponderance of the evidence. So reasonable doubt is not at play there. And so I'm not sure exactly what you're asking me, Tracy. Patriotic says the public will never let it go and the feds are still investigating. Microdot says getting Marcy and the officials is more important. Sylvia's daughter says, please explain how the feds got involved. And did all these evildoers know the feds had their emails? Well, the feds got a hold of a lot of text messages of the McCabe's and the Alberts and their group text messages, and also the text messages of Proctor's. And we don't know exactly why the feds got involved. It's like, what came first, the chicken or the egg, right? We do know that as a result of the feds getting involved, somebody was actually arrested for the murder of Sandra Birchmore, which had been ruled a suicide, and which the Canton PD and MSP, many of the same players involved in Karen Reed's case, had quickly dismissed as a suicide. We know that because of the federal investigation, Matthew Farwell was arrested for her murder and the murder of her unborn child. We don't know exactly why they got involved. We don't know exactly what they were investigating. Did they stumble upon Karen Reed's case as a result of the bigger picture that they were looking at? We don't know. And I don't think that the McCabe's and the Alberts knew until the trial that they had these things. It looked like to me that Matt McCabe was completely surprised. However, the rule in Massachusetts is you have to turn over all of your smoking guns to the other side before the trial. And so some of them maybe were prepped on those text messages. I don't know, but it seemed to me like Matt McCabe in trial number 1 was very surprised. And that's a great question. Thank you, Sylvia's daughter. Still waiting. Yeah, it's a weird rule. Not a rule that we have here in New York, that's for sure. It's like, oh yeah, give us your smoking gun so we can take away your smoking gun and we can prep our witnesses on your smoking gun. Okay? Susie Q says, I get the too big to fail vibe after yesterday's hearing. The judge should be upset too, not laughing, in my opinion. I know. Agreed. I mean, a lot of people feel that way. I felt like he was laughing along with us, that we all could see how ridiculous this persecution was, and that he was specifically laughing about the title of the video being Cosgrove Gets Frisky or something. And then Cosgrove apparently joked on the way out to Aiden that he was going to go on Ratchet Madness and told everyone to vote for him. So you can't even make this stuff up, you guys. You really can't. Thank you, Susie, for your super chat. You made mistakes in your emails. Is not sure if it knocked me into the middle of next week. I will have to let you know. I have now found out what it feels like for someone to serve the ball hard in tetherball and I stop it with my face. It's your birthday? Happy birthday to you. Happy birthday to you. Were you really playing tetherball? I'm very confused. Happy birthday. In any event. I saw the camera come on, and then it went off again. Thank you, little cupcake, for reminding everyone to please remember to like the video and subscribe to receive notifications. It's free. All right. Jerks switched to a different stream. Is it a different courtroom? He may just have a different screen up. Hold on. Is anybody boots on the ground there? Are you in the court? He just changed the pin. It's courtroom 25 as far as I know, and that's what we're in. If they're in the big courtroom, then it's a different Zoom than what the clerk gave me, but I'll try. But they don't have any feet up either. Is anybody there? Do you know if they're in the big courtroom or in courtroom 25? I'm in courtroom 25, which is the small one. Is anybody in the building? Something's happening here. All right, we got somebody. We got somebody on. And Young Jerks has the same person on, so we're in the same place. No worries. Thanks to you guys for being concerned. Is there anybody in there? Hey, girl. Hey. Hey, girl. Don't worry. She's at home chilling. She's chilling. She doesn't know that she can turn off her camera, maybe. Well, here's everybody who's in there. So you can see that Baker is here. Baker's in there twice. Court TV is in there. MM is in there. Michael Marcy. Do you think that's Michael Marcy? What do you think? Larry Tipton is here. Here's Norfolk Superior Court. Mike Crawford. Somebody just named M. WBZ is here. And we're all in the same place. Court TV. That's it. Bob Smith. The cold case is Christopher Wolfenbarger, and they're starting testimony today. Is anybody interested in following that case? Somebody sent me an email about it, and I took a little look into it, and it looked interesting to me. I don't know how long that trial is going to be, but I feel like we need to watch a trial soon or we're all going to go crazy. The hush before the Stormin Scapicchio. The barbecue. This is the one that's going to have the video. Okay, I finally learned how to work Zoom. It only took 5 years. The courthouse still doesn't know how to work the Zoom. They don't know how to mute everybody. And that's why we got the free Billy Tibbetts. But Billy Tibbetts is not a good guy. I looked him up. What he did was really bad. Thank you, Bob Smith. Is anybody following that trial? Maybe if it's not starting till this afternoon, I can catch up on it later. Thanks, Bob. You made mistakes, says Melly. Those were things my mother used to say to me. I will knock the taste out of your mouth if you do not stop. The bands hit me in the face. Oh, that's terrible. Exercise is dangerous. I didn't know that Aiden Carney actually really did run the Boston Marathon one year. Found that out yesterday. Stephanie says, my heart hurts for John that his family is so brainwashed and more concerned about money than they are about what really happened to him. Sad, right? It's our 1 year anniversary, Lynn. Happy anniversary to us. Live, laugh, Lorazepam says, this is so frustrating. Wish they would just release all of his texts and emails. I can only imagine what is buried on the McLaughlin. Thank you. Karen says, justice for Francis Gigliotti. Is that how you pronounce his name? Gigliotti. Thanks, Karen. Super chat. Mary says, be great to see the three, Higgins, McCabe, Albert, arrested and then begging Jackson et al. To represent them. It could never happen. It's a conflict. And they hate him so much. They hate him so much. Jackson would probably want to be special prosecutor. Thank you, Mary, for your 10. Chrissy Melanie Marcy has a neighbor who had an amazing free Karen Reed sign on his truck so he could see it every day. That's awesome. Love that. I love that. Tina Lewis became a welcome. Piney Woods is here. Good morning. Hello. 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 Thanks for being here. Look at, you made mistakes in your email. Gifting 10 attorney Melanie Little memberships. Welcome to the 2 new members, the 10 new members. Happy birthday to you. And thanks for sending me a gift on your birthday. Sam says, y'all need to get outside and do a rain dance to get this thing started. Thank you for gifting 10 memberships on your birthday. Mama Rico says, I agree. We 100% need a trial with you soon. I know. I feel like we're going through like trial withdrawals. Although the rest of this month is very busy for me because, it's back to college. It's back to college time. We got to go. Everybody's got to go move into the new housing and mommy's got to get on a plane a couple of times. So it's a busy month. Look at Robin is so depressed that she just found out about me in May. That's okay. You can go back and watch everything that you missed. But I'm happy that you found me now. So we got that going for us. Look at Tina. On my screen, it says Tina Lewis became a member at 2:27 p.m. Well done, Tina. Well done. Did you time it just right? Sherry Green says today is my sister's 62nd birthday. Happy birthday, Sherry from Canada. Happy birthday. Just a little technical perjury says, show us the papers. We read the papers before. Yeah, just a little technical perjury. That's what Carrie Roberts said. Well, technically, it's not perjury because I didn't understand the question. So technically, it's not perjury. I feel like I should, do like a little song and dance here because so many of you are waiting. 10,185 of you special people are here watching with us, just waiting for them to start the camera. on this hearing that we seem to, it's like Groundhog Day. It's like every day is the same. All right, I hear this now.
Could I have the two gentlemen that are in custody brought in, please? Thanks a lot.
Brian Walshe is like, can you get me out of jail today? I don't want to come on Zoom. I want to come into the courtroom, please. And we get to look at Jim's forehead, which, how sad is it that I know what Jim's forehead looks like? Oh, here's Larry Tipton. He's on Zoom. But I think Brian Walshe was going to come in.
Mr. Tipton, can you hear us okay?
Yes, I can.
Thank you. No, I don't need Is Mr. Walsh there on the video? I just don't see him. I don't need to see him, but is he there?
I don't see him.
Yeah, no, neither do I.
Yes,
the
sir.
sheriff's office is there.
Yeah,
I just don't. Here we go. Oh, maybe not.
we can go get him. 1 second.
Great, thanks a lot.
It's 2:36. The hearing was at 2.
Let's start with identification. Let's start with the Commonwealth.
Good afternoon, Your Honor. Lisa Beatty for the Commonwealth. I'm at the table right now. There are various other assistant district attorneys who represent the trial teams on the various cases who are also present in the courtroom.
Okay, thank you.
Good afternoon, Your Honor. Rosemary Scapicchio on behalf of Mr. King as well as Mr. Johnson. I am sitting in for Attorney Cataldo with respect to the co-defendant of Mr. Johnson's case.
Okay,
Good afternoon, Your Honor. Nicole Scapicchio on behalf of Mr. King and Mr. Johnson.
thank you. I have Mr. King in the back, okay?
Attorney Joseph Krosky Jr. on behalf of Jovani Delossantos.
Okay, and he's here. Okay, very good. And Mr. Johnson is here.
Yes.
On the Zoom is Mr. Tipton. Mr. Tipton, could you identify yourself for the record?
Yes, Larry Tipton for Mr. Walsh. Attorney Porges will not attend today.
And Mr. Walsh is here. Mr. Walsh, can you hear us? You can just wave or whatever.
I can hear you. Thank you.
Thank you.
All right, Mr. Tipton, we still have to fix your microphone. Still tough to hear you, sir. All right, where do things stand, Attorney Beatty?
Your Honor, I've had the opportunity to have further conversations with the U.S. Attorney's Office, and I can report the following to the court. Ordinarily, the U.S. Attorney's Office would have 2 weeks to reply to the motion that the Commonwealth filed in federal court. We've had some productive conversations, and we're hopeful that we've reached an agreement that will narrow the issues for some period of time. They will be filing a response to our motion in court, seeking modification of the federal protective order, which will do a number of different things. The first thing they will be seeking a modification that will permit the release of the previous court orders so that this court can review those orders. The second thing that the motion for modification will seek is permission for the Norfolk District Attorney's Office to review the remaining confidential materials that were provided to the Reed and the Reed prosecution and defense teams. So I want to be clear at this point for the purposes of the record that at this point in time, all of the Proctor chats or communications have been produced to the Norfolk District Attorney's Office outside of the protective order, and the Norfolk District Attorney's Office has provided those to all of the defendants who are part of this motion and will continue to provide those to other defendants. However, that left the remainder of the confidential materials, which we had not been allowed to review. So the motion will seek permission for us to be allowed to review those additional materials. I would characterize those.
That's the motion that you filed before.
We filed a motion for that, seeking that among other things. The U.S. Attorney's Office will file their own motion.
And they'll file a motion in accord with yours?
No, because there are what I would characterize as two groups of remaining materials. There are grand jury materials and there are non-grand jury materials. Their motion will allow us to review both sets of materials. We will be permitted to produce Rule 14 materials from the set of records that I would characterize as non-grand jury materials. We will not need to seek further court order or permission from the U.S. Attorney's Office if we review the non-grand jury materials and find Rule 14 materials that is relevant to the other matters. We're calling them the other matters, these cases here that we're discussing. We do not have an agreement with regard to the grand jury matters. So if we review the grand jury matters and we find what we determine to be Rule 14 material, at that point in time, we would have to seek either a TUI or go back to federal court and file an additional motion before Judge Casper. The third thing, this is my understanding that the third thing that the U.S. Attorney's Office motion or response, however you want to look at it, will seek is a status on this matter before Judge Casper in 45 days. So if Judge Casper agrees with that, we will not have a return or destroy deadline that is pushing the matters at this point in time.
And does the U.S. Attorney's Office also agree to the tolling during the period between now and whenever Judge Casper decides?
Yes, they had already
agreed to that.
They had already agreed to that.
Let me just see if I can recap.
Thank you.
As best as I understand it. There are two types of materials that have not yet been produced to the defendants in this case.
That have not been reviewed by the Norfolk Attorney's Office and have not been produced for these cases.
All right, so let me just go slow here.
All right.
Certain documents have already been turned over to these defendants under protective order,
Yes.
which came from the U.S. Attorney's Office.
Yes.
Okay, but leaving those aside, of the materials that are part of the confidential material from the federal court, there are two categories. One is grand jury materials and the other is non-grand jury materials.
Yes.
You haven't yet defined what you mean by grand jury materials. Presumably, if the grand jury took testimony, that would include transcripts of testimony. I don't know if the grand jury issued subpoenas. I don't know, and I don't know if you're considering subpoenaed material to the grand jury to be grand jury materials. But let's leave that distinction aside. Whatever constitutes grand jury materials, there's some other stuff that is non-grand jury materials that was collected by the U.S. Attorney's Office in connection with this investigation related to the Reed case. And what you have is an agreement from the U.S. Attorney's Office that as to the non-grand jury materials collected by the U.S. Attorney's Office and produced as confidential material in connection with the Reed case, the non-grand jury materials, even the U.S. Attorney's Office would agree to allow you to review and to determine whether anything in that material should be produced in King or Johnson or Delossantos or any other of the cases that involve Trooper Proctor's investigation. As to the grand jury materials, they still are opposing your ability to produce any of that material and opposing your ability to review any of that material. Is that correct?
No.
No.
We are allowed to review those materials in order to determine whether, in our opinion, there is Rule 14 material.
Okay. So at this point, they're taking the position that the non-grand jury material may be reviewed by you and turned over without further order, although I guess it's subject to their production of the documents to you other than through the, under the protective order.
I think that we don't have this finalized yet, but my impression was that we would be able to use the documents that we already hold.
Okay. And are they taking the position, the U.S. Attorney's Office taking the position that notwithstanding the protective order issued by Judge Casper, they can make that determination unilaterally?
No.
So they're seeking a modification of the protective order to allow them to give you the authorization to review it separately?
Yes, so this is all subject to Judge Casper's approval.
All right. And then with respect to the grand jury material, however that category of universe is defined, the U.S. Attorney's Office is taking the position, at least as in front of Judge Casper, that you can review it and all of all the other prosecutors involved in this case, the other cases, the related cases, can review it to make a determination as to whether it contains anything that needs to be produced as exculpatory evidence or impeachment evidence under Rule 14. And
know that it will be all the prosecutors in the office. I think there will be at least 2 prosecutors in the office, 2 prosecutors probably who have already signed the acknowledgement, who will be able to do the review.
Okay, the U.S. Attorney's Office is asking for a status conference in 45 days. Presumably, Judge Casper might decide it much sooner than that.
I think what they are hoping is that they will file the motion, Judge Casper will act upon the pleadings, and then the 45 days would be scheduled from whenever it is that she issues her order, assuming that she adopts this proposal.
Well, what's the 45 days for?
For a status to see where we are. I don't know how long this process is going to take.
Oh, you mean a status on the return of documents after this review has taken place?
Right. I don't know if we'll be able to do the review in 45 days. I'm optimistic, but you know, anything can happen. And so I think the suggestion was this way we don't have this deadline that is just pushing everyone. And so then we can see if we've been able to complete the review, if we can continue to discuss the issues that remain, or if there needs to be further litigation or what needs to happen.
Okay, so we are making progress, incremental progress. I have not received any new filings from you or from anybody else between the last hearing and this hearing. So all of this is being reported to me for the first time orally here in court. Maybe it's true also for defense counsel hearing it for the first time here in court. Does defense counsel have any thoughts, concerns, issues?
There you are.
I'm sure you have thoughts and concerns and issues, but you know, my gut feeling here is we're going to need another hearing on this, and I'm not sure that less than a week, you know, or a week's time, anything longer than a week might not be appropriate, because we don't know what Judge Casper is going to do. We don't know if she's going to adopt the tolling. We don't know whether.
That's exactly what
what
Judge Casper says.
Right. It seems to me unlikely that she would say no, but I don't know, and I can't assume the conclusion here. So,
Is there, I guess, can I ask a question, Judge?
sure.
Is there any agreement between the Commonwealth and the U.S. Attorney's Office not to destroy the documents until Judge Casper makes a decision? And can we have a day after that decision to get in here and talk to you?
What do you think?
Well, I've always said that we would not return or destroy before Judge Casper made a decision, and that the U.S. Attorney's Office has agreed to that. I do want to say that I'm out of state next week, so I would be asking to go to the following week. If something comes up, I can get on Zoom if necessary, but.
So the only concern I have, and I'm never going to interfere with anyone's vacation. The only concern I have is if Judge Casper makes a decision tomorrow or Monday that says this order isn't getting extended for whatever reason, where are we, Judge? That's my concern. If this order expires, the order that we have right now, I know there's an agreement between the Commonwealth and the U.S. Attorney's Office, but it's not their order, it's the judge's order. So if the judge says no on Friday or Monday, then what happens?
What do you think?
I will notify the court, and I will get on Zoom if that happens.
Okay.
Judge, just on behalf of Mr. Delossantos, again, in theory, this does sound like progress. I do share the concern if a decision comes out from the federal court from Judge Casper. I'm comfortable enough with a 2-week date, with the caveat that if circumstances on the ground change and the landscape in federal court changes, that we could have this case advanced to address the court.
That's where I was coming down, okay, is put this on for a next hearing, August 27, 28, 29, something like that, convenient to the parties, dog days of August, with the additional order that upon a decision by Judge Casper, all parties, all defense counsel, and the court will be notified within 24 hours so that we can accelerate proceedings on this case if need be before the 27, 28, 29.
Because I'm not available on the 27th because I have an all-day motion for new trial here in Suffolk. Do what I have on the 28th, make myself available if that works for the court and the parties.
The 28th or the 29th is better.
I'm here on the 28th.
Okay, so the 28th at what time?
Let's do.
Yeah, let's do 2 o'clock.
Sure. And may Mr. Johnson be here, Jen?
Yes.
And I'll have Mr. King here.
Same with Mr. Delossantos.
Okay. Mr. Tipton, how do you look on the 28th of August?
I'm fine, Judge. I'll appear, if I can, I'll appear by Zoom. If I can be present, I'll be present, but I'm there.
Okay. Zoom will be an option for you.
Thank you.
Anything else we should take up?
Judge, I don't want to believe.
Looks like we're making some progress, and I feel confident now that the information isn't going to be destroyed by Monday, and if it is, we'll have an opportunity to speak to you before that happens.
Okay. Mr. Tipton?
Yes.
The only thing I want to say, and I'm not going to belabor it, we'll address it on the next one, but we have in my case, we have a trial date coming up in October. If we're talking about 45-day status date, then we're talking about the grand jury, then we're talking about TUI. I'm just putting a bug in everybody's ear that we do have an October trial date, and everything needs to be done expeditiously in the Walshe case at a minimum. I'll leave it at that.
The Commonwealth is mindful of the Walshe trial date and has expressed to the U.S. Attorney's Office that we are anxious to bring that case to trial and do not want there to be any delay, and we will be acting accordingly.
Judge, the only other concern I have is the 2 attorneys that are going to be authorized. I would assume that they would have conversations with the attorneys that are assigned to the case so that they know.
I'm not going to micromanage the district attorney's office's obligation to produce all exculpatory evidence. They will have to bring somebody up to speed so that if they are limited in who can review the capital C, capital M confidential materials as defined in the various orders, that those people are in fact up to speed.
Thank you.
Okay.
Thank you, Your Honor. Thank you, Mr.
Thank you.
Thank you, Mr. Clerk.
Sure. 27 at 2 p.m.
28th, I believe.
28, yep.
28, sorry, 28 at 2 p.m.
Thank you.
Thank you.
Thank you.
Thank you. Could I have Mr. Buckley brought in?
And that's it. We're done. We're done. See how frustrating being a lawyer can be? Do you see how it can suck the life out of your soul when the wheels are stuck in the mud forever and ever and ever? Remember, this is also a very unusual situation. This is a very unusual situation, but I have some questions. Let me just recap for you what just happened here in case you're looking at me like this whole thing was over my head and it was Greek to me. There are 5 defendants involved in this issue, and the issue regards Proctor's communications in the Karen Reed matter. And apparently, in addition to Proctor's communications, there is some grand jury material at issue and some non-grand jury material, which is separate and apart from the Proctor communications. That's what I was understanding from that. The DA's office says that they have turned over everything involving Proctor's communications to all the defendants, that they have that stuff. They have said that they made a motion in federal court so that asking for them to be, for the federal court to allow them to give the defendants the federal order, because none of the defendants even have a copy of this federal order that they keep talking about. because the DA's office has said, we think it's in violation of the court order, the federal order, to even give you the federal order. So they want the federal Judge Casper to order that it's okay for them to give them the court order or orders, because there's several of them. And then they're looking to the federal judge, the DA's offices, for permission to review the additional materials, the grand jury materials and the non-grand jury materials. They want to be able to review all of that stuff because they feel, in their opinion, that it would be a violation of the federal order to even review the materials. In which case, if there's anything in there that's exculpatory, they may have to then make another 2E request or go back into federal court to get an order to have it released to the defendant. See how long this kind of things take? And then if they don't hear anything, they're hoping that Judge Casper will give them status in 45 days. And so they'll go back in 45 days to the federal court judge. But Lisa Beatty's going on vacation for the next weekend. So everyone was concerned that if something comes in from the federal court, they won't know. And she said, I guess she'll check her email and she'll turn it over to them within 24 hours and they can all come back. But at the very least, they can all come back August 28th at 2 p.m. What are the federal grand jury materials that they're talking about? Because we know that the federal grand jury, when it was commenced or convened, sometimes federal grand jurors sit for 18 months, a year to 18 months, and they hear many, many cases. We know this because one of the grand jurors has been indicted in federal court for releasing information about not only the Karen Reed case to a friend, but also the CDL scandal, where some law enforcement officers were trading commercial driver's licenses to guys in exchange for things like driveways, plunge pools, Voss water, and landscaping. So they were just handing out like candy commercial driver's licenses for guys of these employees of these landscapers and contractors to drive 18-wheelers in exchange for the stuff they were getting at their house for free. What else did the federal grand jury hear about? Makes my little spidey senses go, What else? What else did they hear? Because if there's grand jury materials and non-grand jury materials, that maybe that's other stuff that doesn't have anything to do with Karen Reed, right? The snowblower, that's right. They did give away snowblowers. Thank you, Scott McGinnis. So is there information out there that the federal grand jury was investigating that may have something to do with some of these other defendants' cases, but has nothing to do with Karen Reed? I'm curious now. Because the grand jury hears lots of things when they're convened, right? We know a lot of the witnesses in Karen Reed's trial were called to testify in front of the federal grand jury, including law enforcement and many of the Alberts and the McCabe's. What else was going on in there? Dun, dun, dun. Let me know what you think. Tracy says, oh no, Laura and Lally, she means, right? Laura and Lally to review the federal grand jury information. Well, both Adam Lally and Laura McLaughlin were on the Karen Reed case. So yeah, maybe. Brent says, Dear Kerry Roberts, Norfolk DA's office and feds, ignorance is no excuse for breaking the law. Perjury was admitted to. Where are these charges? Ashley, Melanie, do you think ARCA has more information? About what? I think everything ARCA did for the feds was turned over to Karen Reed's defense by Josh Levy. Do I think they were hired to investigate any other cases for the feds? I have no idea. I don't know. I don't know. So could there be grand jury information? I don't know. I mean, it's an interesting thought, Ashley. But being that I just really thought about this, like right exactly now. Yeah, MassDOT said ARCA's work is done. They won't do anything more without being paid. That's true, but could they have done other work for the feds on other cases that we just don't know about? I don't know, but I think that all of the payment records to ARCA have been released, right? Didn't people make like FOIA requests for that? Michelle says, I don't know how to get this advice to Turtle Boy. He could get nationwide coverage of his case by calling into the Mark Levin show on Sirius XM radio on the Patriot Channel on channel 125, nightly or midday. Well, maybe he'll watch the show and he'll take your advice. He's on Howie Carr a lot. So I don't know about Mark Levin. I don't know what he covers, and I don't know Nationwide is on your side. I don't know if he'd be interested in covering it, but that is a good idea. So if anybody wants to get him that information, that's great. What about Proctor's text? She says that all Proctor's texts have been released to everyone with regard to what was exchanged in the Karen Reed matter. But other defendants are saying, well, we want more than that because our cases go back before 2022. And Proctor destroyed his phone. So we want that. Yeah, the snowblower was in exchange for a commercial driver's license. You're right. Oh, Levin is a First Amendment guy. Thanks, Gina. More eyes on it, the better, right? My grandmother was a big fan of him. Of his. Thank you, Columbo Wannabe, for buying me a matcha latte and for thanking me for what I do. It is my pleasure. As always, it is my pleasure. Thank you, DBK in Maine, for buying a matcha latte. Thanks for making every day brighter and filled with class and cupcakes. You're very welcome. Thoughts, questions, comments, concerns before we wrap for the day. This also is not solving the issue of continuing the evidentiary hearing on Rosemary Scapiccio's motion to dismiss, in which Proctor testified. Proctor was supposed to testify, and Lally was already on the stand. So that is a whole other issue, and I don't understand why we're not getting back to that and putting Lally on the stand and putting Proctor on the stand, because that has to do with Myles King's motion to dismiss. And there doesn't seem to be another date on the calendar yet for that. That's what I really want to know. When's that going to happen? What happened with those charts and those graphs that they had to talk about amongst the parties and decide what was turned over too late and how it was prejudicial? We didn't hear anything about that today. You made the mistakes in your email. Hit the thumbs up, everybody. 9,900 people here and 4,100 likes. I'm going to go back to engraving the silver bracelets. Well done. Well done. Not that, Lindsay says. I bet money the feds are not done. Otherwise, why wouldn't they just release the info? Karen T says, so if anyone's in an accident with the driver having a CDL from Massachusetts, they need to get an attorney and go after the company driver. I remember when the scandal broke because I covered it on my channel. It was like January 2024. And somebody had put in the chat that there had been like a massive accident in New Hampshire with an 18-wheeler. And we didn't know if it was related to being one of those freebies, those free commercial driver's licenses that they were giving away. But the story's wild. Deneen said exactly right. Yeah, when can we get back to that hearing? Rosemary Gallagher says it won't happen. I want Lally back on the stand. It was just starting to get good. Thanks, Teresa, for becoming a new member. Did they ever get the search warrants? Out of sight, out of mind. They're probably hoping with their testimony, in my opinion. Right, that was the hearing that got cut off on Tuesday. But even when I look in the court notes, let me look again and see if they put anything in there since then. Even when I looked in the notes, they had it. Myles King, by the way, was let out of prison or let out of jail on bond, and he's an alleged, murderer. He's out there on the streets because, it took so long. But, no big whoop. And so, he doesn't care. He's like, whatever. It takes as long as it takes. I'm not in jail anymore. When does governmental misconduct become so egregious that a judge in Norfolk County or Massachusetts does anything about it? Right? The last thing that I have in the docket on Myles King. So on the 12th, which was 2 days ago, the Tuesday hearing, it says the hearing was held as scheduled. And then on the 13th, which is yesterday, Michael Proctor, third party Michael Proctor's amended motion for clarification of court's memorandum and order dated June 17th, and for protective order and certificate of service dated 8/12/25. Somebody said in chat he's asking to not have his testimony televised. And there was an order filed yesterday, a clarifying order regarding examination of former state police trooper Michael Proctor's cell phone, filed by the court and emailed to the parties yesterday. I don't have a copy of that. And then yesterday, the judge signed an order. The Commonwealth made a motion for a protective order for production of chats. I don't know what chats those are, and I think that was with regard to all of these defendants, and that was ordered. They got a protective order against that. It's like it's Groundhog Day. Same stuff, different day. Thanks, Teresa, for becoming a member. And you made mistakes, says, please have a good weekend. I know it's crazy time of year getting your kiddos back to school. Thank you so much for your time. Thank you so much. Thoughts, questions, comments, concerns before we wrap for the day? Anyone? All right. Thank you to the moderators for keeping it classy today. It wasn't so bad, right? It wasn't so bad. 2 hours. 2 hours, relatively tame, I think. A lot of waiting, but that's what lawyers do. We wait. We get frustrated with the process. It takes forever, and it sucks your soul. Everyone smash the like button, hit the subscribe button. It's free. Make sure you have notifications enabled on your phone and whatever devices that you use, because, YouTube likes to unsubscribe people. And so there's that. Oh, tomorrow's only Friday, so I'm sure we'll find something to talk about by then. So you have to make sure you have your notifications set so you know what time I'm going to go live and what we're going to cover tomorrow. And if you have any ideas of what you want to talk about, just a comment, and I read all the comments when I can. Stay cool, stay kind, stay classy, my friends. Peace out. I love you with all of my heart. I'll see you tomorrow. Not sure what we're going to talk about yet, but we'll be back. Have a great rest of your day.